I thank the gentleman. And you know what? That means it's my turn. I yield myself a little bit of time here. We'll start with Professor Duan. Now, Huawei cannot produce products inside the United States, but they are second only to IBM for the most patents applied for every year or received. Would you give us a contrast of the quality of that amazing quantity and where some of those end up?
Yeah, so there are a couple of things that are going on here. The first is that there is a strategy across China, and particularly with companies like Huawei, to obtain large quantities of patents. Now, one way to get a lot of patents is to just file as many things as you can and see what sticks to the wall. And so we've had a number of studies looking primarily at China's international portfolio that have identified serious quality concerns with the patents that China is seeking.
And is that because when you're a large company that applies for a lot, you tend to have a team of lawyers that are just really good at squeezing through patents by whatever means you need to have them survive?
It's that, and it's also just a volume game, right? The more that you can file, the more words that you can put down onto the page, the more chances you have of getting through. But that's not to say that China's just or that Huawei is just filing sort of across the board. They're focusing on particular strategic areas, and we just had a conversation about technical standards in communications. China and Huawei particularly are leading in filing of applications that are required by the 5G and other technical standards. They've also taken other measures to be dominant in those standard-setting processes. What that means is that those patents now must be used by any device that implements those technologies, such as 5G. These are not ordinary patents anymore where somebody can say, okay, so we're worried about this patent, we'll figure out a way to work around them. They're necessary in order to work with the infrastructure. That gives China a substantial leg up in enforcement when it comes to those sorts of technologies. And so the way that companies have tried to deal with, or the way that these standards organizations have tried to deal with,
even my time can be limited. let me just sort of narrow the scope here. My understanding is Huawei also licenses out their patents, in many cases patents they're not using in the United States, license them out to venture organizations. Can you opine on that if you know?
They do, and I think that I've seen a fair amount of evidence of transfers of patents, especially these sorts of standard essential patents, to a variety of different entities. Now, one problem is that, as Mr. Cohen alluded to, we don't know a lot about what's going on. We don't have the sort of transparency measures that let us know what happens to the finances of patents or patent litigation. And I think that one thing that we can really try to build out is building out that transparency in patent ownership and patent litigation so we can see to the extent that Chinese-owned patents or that Chinese entities are controlling patent litigation. I think that that's going to be an important thing to look forward to.
Mr. Cohen, we've given you a lot of questions on trade secrets, but it's fair to say that companies like Lam and Advanced Materials are global leaders, two of them, but even when they have trade secrets, even when they produce unique product, their customers sometimes have trade secrets beyond that. Taiwan Semiconductors makes chips using their equipment that other people using their equipment currently cannot. Just briefly, Taiwan's non-compete and secrecy laws as contrasted with us, are theirs tighter than California?
Taiwan, like mainland China, permits non-compete agreements. As with many other European countries, they're limited in duration, and you have to provide some form of reasonable compensation for the duration. So that limits the application of non-compete agreements to highly skilled, compensated employees where it's really important.
But it's fair to say that we cannot compete against those countries if they have that kind of non-compete that are essentially protecting their trade secrets and their developments, and we don't.
That's correct.
Okay, Mr. Greer, one of the questions that I have for today, oddly enough, is the TRIPS waiver that the president did related to COVID-19. One, would you, in your old boss, have recommended any sort of a waiver? And if so, would you have limited the waiver to not to the patents themselves, but to production of the product? Meaning, you can produce the product, but you cannot have, if you will, access to the technology going forward.
Well, sir, the waiver was first requested in 2020 and was presented to Ambassador Lighthizer, who declined to endorse that.
So that part of the answer is yes?
That's right. So that's that. You know, the TRIPS agreement already has space in it and was amended once already to provide clarity on what we call compulsory licensing, right? If you have a situation where voluntary licensing just doesn't work out and you can't come to terms, it provides for compulsory licensing. And so this idea that you're going to have some additional TRIPS waiver is not only duplicative to some degree of what's in the TRIPS agreement, but also undermines international IP rights going forward at a time when the WTO is already on thin ice.
Now, one quick question for law, and anyone can answer, but Mr. Greer, you might be the best. Under international law, if we refuse to supply a life-saving product, including a vaccine, to a country, they have an absolute right to source it themselves or to essentially invalidate the patent and produce it. Isn't that correct?
That's exactly right. World Trade Organization agreements, they have exclusions for public health and safety. TRIPS agreement itself has a provision where if you can't come to terms in getting what you need, Article 31 and 31B allows you to do that kind of thing.
So there was no denial.
Exactly right, yeah.
Okay, and I'm going to take the liberty of just one quick follow-up question. Mr. Evanita, you've been very quiet for a little while, but we have touched on, but we haven't fully explored the current events that we see, balloons floating over our country, provocative acts, because it's outside our jurisdiction. But when we look at what the FBI director and others have said about the amount of theft being done and its effect, today we kept repeating the $600 billion as though money was the problem. From a standpoint of the global conflict and the ability not to economically compete, but militarily, would you close out this hearing with the, if you will, your view on what that means around the United States from a standpoint of our security with that much intellectual property being stolen every year, not in dollars, but in risks to the American people?
Thank you, Chairman. And that's going to be a long answer, but I'll keep it quick.
Well, you're going to have to make it a little short because a lot of people want to leave here.
I think
you're the closer.
This hearing on intellectual property, very minute aspect of the threat posed by the Communist Party of China. I think your question, the threat to the homeland, starts there, but also looks at the surveillance and penetration of our critical infrastructure, our gas, natural oil pipelines, our electrical grids, our ports, our maritime facilities. The preamble to any kind of future conflict, the Chinese Communist Party has spent a decade preparing for that battlefield for us, not only in a corporate perspective, but a military perspective. It starts with energy, power, and financial services. So I think when you look at what the Chinese Communist Party looks at us, is be able to pre-conflict, during conflict, prepare the battlefield so we cannot act in that battlefield. And that starts with the critical infrastructure.
Thank you. And as much as I would like a second round, I'm going to have to ask all of you, would you be willing to take questions for the record? Since I have all yeses, all questions submitted will be left open for 5 days and a reasonable amount of time for the answers so we can have a complete record. As I said in the introduction, this is the first. It is clear that we only really touched on many of the areas we have to work on. I will say that when we look at intellectual property, I deliberately closed out on the national security risk because I believe that this committee has an obligation to look at IP protection, including those that might affect trade secrets and the like, as being part of our national security. And for that reason, I wanted to close on that, and I appreciate everyone's indulgence.